Down LLC unverified. Wow.
Hello, Cliff.
Hello.
How are you?
Good.
Are we on yet?
I think there are a whole bunch of us who are on, just waiting.
Oh, just waiting. Okay.
Hello. Happy Wednesday. Please keep your mics on mute until your docket is called.
There it goes. There it goes. Oh, yeah, turn the cameras on. Yep.
I don't see Mr. Bradley yet.
You hear me? Do you hear me?
Yes.
Okay.
Happy Wednesday, everyone. Please keep your mics muted until you hear your docket call. Once your docket is called, you will hear a brief description on the code enforcements that was brought against your property. You will then say your first and last name and your relationship to the property for the record. Mr. Chairman, we can begin with the preamble.
In compliance with notification requirements of Ohio's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1796. Notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department can conduct their meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record before the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile versions and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also use the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located at the bottom of the WebEx screen. All meeting activities being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak on a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comments on a particular matter. Mr. Jacobson.
Thank you, Mr. Chairman. This is Dan Jacobson from the Law Department. Preliminary issues, the live stream. Can we verify that the live stream is on and functioning?
Through the chair, yes.
Thank you. And Mr. Chairman, as the Law Department has done since these public meetings have gone virtual and or hybrid, law states its objection to the use of the chat function. Thank you.
Thank you. Ms. Davis.
Mr. Bradley,
Here.
Mr. Maskey,
Here.
Mr. Dink,
Here.
Mr. Gallagher.
Here.
We have a quorum.
Thank you. We'll call the first docket, building docket A 243-24, 428 East 152nd Street.
Application and fees are in order. Notice of violation is condemnation of the main structure dated on October 24th for 2024. Appeal was received December 13th, 2024, requesting for 6 months to 180 days to complete abatement of the violation. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastro for the Law Department, Tom Vanover, Chief Building Official. Will the applicant or his or her representative please state your name, your first and last name, and your relationship to the property for the record?
Good morning, everyone. Michael Weary, appearing for VFI Holdings, LLC.
Mr. Weary, do you swear or affirm to tell the truth, the whole truth?
I do.
Okay, go ahead and proceed.
So we filed our appeal. This is a property that is obviously multifamily. It was received by VFI Holdings. They took title to the property by way of a sheriff's deed in foreclosure. VFI Holdings provides financing. They did for this building some time ago. Obviously, things didn't work out. They proceeded with the foreclosure in the common pleas court. And they were the purchaser at the sheriff's sale and obtained a deed in Actually, the deed was received late 2024, November 13th, 2024. So recently, they asked for 6 months. They are not, as a financing company, they are not a company that has the resources to fix up a property or rehab it and bring it into code. So they marketed it for sale, asking for the 6 months to try to get somebody in, purchase the property, make the necessary repairs, and work with the city to cure the violations at the property and rehab it. They had a few sales that fell through, but very, very recently, they did find a buyer for the property, and the deal closed to sell the property just this past Friday, May 16th. The new purchaser will be a gentleman named Colin Barth, Barth. Mr. Barth and I had a conference, and he advised me that he has already been in touch with the board of the Board of Building and Housing, that he does have the resources and intends to rehabilitate the property into code and hopefully more. So, you know, I understand where this building is located, and you know, next to a school, and Mr. Barth realizes that too. He was aware of you know, the condition and the situation with the city when we went into the sale, and was a willing purchaser due to his ability to be able to rehabilitate the property. I understand he has plans ready to go, some sort of plans, you know, that could be presented at some time. I am not sure if he is here today. I recommended that maybe he could appear and I could introduce him. However, I did not see his name on the list, but I'm not sure if he's here. I did talk to the city inspector at times. Our city inspector here, I just have the name Bonko. I spoke to him, and I think he was aware also that we were trying to bring some purchasers in, but thankfully we did get somebody. We hope that he can work with the city and moving forward, you know, expedite and bring this property into code.
Okay,
That's all I have. Thank you.
Okay, Mr. Weary, you are representing VFI Holdings LLC?
I am.
Okay, all right, very good. I'm going to go over to Mr. Vanover. Mr. Vanover?
Mr. Chairman, to Ms. Davis, can you read back the address for this property for me, please?
Yes, through the chair to Mr. Vanover. The property address is 428 East 152nd Street.
Okay, that's what I got. Thank you, Mr. Chairman. The city would ask at this point that you deny any more time and remand it back to the Department of Building and Housing. This was a commercial real estate investment. I'm a little confused with the testimony that the purchaser is not a company that has resources to do rehabilitations. I don't understand why companies buy properties that they can't resource. And simply transferring it to a new owner does not relieve the appellate's responsibility to bring the property into compliance. It only relieves their access and ability. They would still be responsible under the City of Cleveland Joint and Several Cost Ordinance, to where if the city is required to raise this structure or demolish it to abate the nuisance, both the previous and present owner will be responsible for the costs. So I would ask that you deny more time, remand it back to the department. The new owners can do what the new owners are going to do, but granting the previous owners more time would not bear fruit of any kind.
I think the rest of the board would agree with that. So a motion is in order to deny more time and remand the property to the Division of Building and Housing for any further action. Motion?
So moved.
All right, moved by Mr. Maskey,
Second.
second by Mr. Denk.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, thank you. Notice will be sent out within 2 weeks.
Thank you.
Next docket, building docket A 249-24, 3935 West 130th Street.
Application and fees are in order. Notice of violation is exterior maintenance, issued on November 21st of 2024. Appeal was received on December 5th of 2024. Applicant did not state how much time was needed to complete abatement of the violations. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastural for Department of Law, Tom Vanover, Chief Building Official. Will the applicant or his or her attorney and/or representative please state your first and last name as well as your relationship to the property?
Your
Nasser
Honor,
Najjar.
Yeah.
Go ahead, Cliff. I'm sorry.
and Clifford Thornton, counsel for Mr. Najjar, is also present.
Okay, so I'll swear the both of yous in, Mr. Najjar. Okay, Mr. Thompson, do you swear or affirm to tell the truth, the whole truth?
I do.
I do.
Okay, whoever's gonna be speaking, go ahead and state.
Yeah, Your Honor, this is Cliff Thornton, attorney here in Cleveland. This case originally emanated out of the housing court. Mr. Najjar owns a gas station, grocery store, and there was some concern that the pillars holding up the canopy over the gas pumps needed some reinforcement, which has been done, and that case is the final part of that case is set for next week. But the court ordered a sort of a final inspection of the property, and that's what gave rise to the violations that are before us. The reason we filed this appeal is that we are confused as to what it is the violations are wanting us to do, because there are 4 violations. The first one is has to do with wall siding. It's saying it's loose and deteriorated, but this is a concrete block building. There are no nothing become loose and on the exterior. So as you can see by the pictures that we submitted, and the same with the gutters and downspouts, there are items 3 and 4 say offered about 10 allegations about the downspouts and the gutters, but as the pictures demonstrate, that they're in good shape. So we decided to file this appeal just to make sure we did something and didn't ignore it, but there's nothing to be done here.
Mr. Chairman, and through the chairman to Attorney Thornton, I apologize about cutting in, but it appears that this is an administrative appeal, and as such, the city has the first administrative burden to demonstrate the violations. With that in mind, I think for purposes of having for expediency, I think we could hear from the chief building official to further clarify the violations, if that would be okay.
Sure, that'll be fine. Mr. Thurman, we'll come back to you. Mr. Vanover.
Yes, Mr. Chairman, because he's objecting to the violations, I would like to point out the picture in the top left clearly shows a masonry building covered with T111 siding. That is wall siding. And then if you go immediately to if we go immediately to the bottom left photo, you can again see the T111 siding as well as other coping and metal that is rotted and deteriorated. The fascia board there is part of the siding. system. It's clear that the siding on this building needs to be repaired, and it is siding. That is not masonry. It's T111 siding. So I'm not sure. We object to the objection to the fact that there's siding on this building. You can see under the overhang that it is, it also has T111 siding strips. So this building is a combination of siding and masonry, and as such needs to be repaired. You can go again to the bottom left. You can see the deterioration of the roofing where it meets the siding. These are things, and this is, if I can finish, and Mr. Chairman, the condition of the downspouts. Because they need to be in proper condition as well. And I think that the photos present shows the deterioration. So we object and would ask that you first determine that the violation notice was properly issued.
May I respond to that?
Yes.
It would help then, in view of what we just heard, that somebody would actually meet Mr. Najjar at the property and point out to him what exactly is the problem here. Because as I look at the pictures and I see the siding, but I don't see any siding that needs to be replaced.
Okay.
Or, I mean, it would be helpful if we had some, instead of just a blanket statement, if somebody would actually show what it is, where the problem is.
Well, I think.
Well, then, Mr. Chairman, we ask that you deny more time, uphold the notice of violation, and the inspector's phone number and email address and business address are all on the notice of violation for the appellant, for Mr. Najjar, to reach out and discuss what is needed. There is an expectation when you own commercial property and you are a landlord or landowner, that you do have an understanding of basic maintenance of the property. And while I don't expect everybody, I don't understand how the counselor does not see the deteriorated unpainted siding on the building. But I would ask that you deny it, remand it back to the department, determine it was properly issued, and we can walk Mr. Najjar through showing him these things that we believe he should already know.
Okay.
That would be a help.
Well, that makes sense. I think that the pictures do indicate it. So the notice was properly issued, and a motion is in order to deny more time, remand the property division of building and housing for any further action. Motion.
So move.
Moved by Mr. Bradley.
Second.
Okay, second by Mr. Denk.
Mr. Bradley,
Yes.
Mr. Maschke,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you, guys.
All right.
Next docket is housing docket A 242-24, 4387 Park West Oval.
Application and fees are in order. Notice of violation is fire damage, issued on November 25th of 2024. Appeal was received December 12th of 2024, requesting for 6 months to complete abatement of the violations. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastoral for the Department of Law, Chief Billing Official Tom Vanover. Will the applicant or his or her appellant and or attorney please state your first and last name and your relationship for the record? Mr. Chairman, I do not see Aaron Murphy in the participants panel, or is that person present in room 514 this morning?
Okay, Mr. Vanover, do you swear or affirm to tell the truth, the whole truth?
I do.
Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, or anything physically delivered to you on behalf of this appellant and or docket?
Through the chair to Mr. Jacobson, no.
To the chairman, the due process requirement of notice having been given to the appellant, the board can proceed with its hearing and ruling today. Thank you.
Thank you. Mr. Vanover.
Mr. Chairman, this property is a fire damaged property that is owner occupied. And our records indicate that they have engaged a contractor that has pulled building, mechanical, plumbing, and electrical permits for the restoration of this property. So we do not object to, and they have contractors working on this work. We do not object to granting until today for the appeal, and then allow the residential code of Ohio to take precedent over the rest of the timeline.
Okay. So motion is in order to grant till today, May 21st, 2025, for the appeal and that the Ohio Building Code will take over from that point. Motion
So moved.
moved by Mr. Dank,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Next docket is housing docket A 244-24-735 Parkwood Drive.
Application and fees are in order. Notice of violation is condemnation of the main structure dated August 12th of 2000. I'm sorry, there's a typo on the PowerPoint presentation. The condemnation was issued on August 2nd of 2012. Renter registration was issued on November 18th of 2024. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastro for the Department of Law, Chief Building Official Tom Vanover. Will the applicant or his or her attorney and or representative please state your first and last name for the record and your relationship to the property? Moesha Hollowell, owner.
Okay, I'm not getting, could you spell the last name for me?
HOLLOWELL.
Okay, Mr. O.L., you swear or affirm to tell the truth, the whole truth?
Yes.
Okay, go ahead and proceed.
Well, actually, I just had bought the property and I got everything situated. I submitted pictures. I just updated the registration to vacant. That's all.
Okay.
And I meant, oh, go ahead. I'm sorry.
I just, what about the condemnation order?
I really don't know what they mean when they say structure of the property. I mean, I submitted the pictures. I mean, I redid the whole house because when I got it, it was no walls, nothing. So.
Okay. All right, let's go to Mr. Vanover.
Mr. Chairman, this property is condemned. It was condemned in 2012. The certificate of disclosure that was issued to Ms. Hollowell in May also indicated that it was condemned. And there are no permits for the restoration of this property. So any work that was done illegally without permits. There's an expectation that building, mechanical, electrical, and plumbing permits are pulled for the restoration of the property. which is the only way to get the condemnation lifted. So that's as a communication to the appellate, you have to pull permits before you do the work.
I had to get the drawing out first to either pull a permit.
Understood? Oh, yes.
Yeah, that's what I had to do
But-
first.
Okay, yes, but Mr. Chairman, to the appellate, the testimony, you gave testimony that you redid all the walls, which is something you can't do that until it's there, you get your drawings, get a permit, and get it inspected. Otherwise, you will be removing the work that you've already done. And you can never legally occupy it until such a time as you get a final inspection.
Yeah, and it's not occupied.
Okay, and Mr. Chairman, so you need to get permits. Mr.
Yeah.
Chairman, I also like to point out that the vacant building registration application that Ms. Hollowell submitted has not been completed. It's in our system as a temp, which most likely indicates that it wasn't paid for or the application wasn't finished. So I'm going to recommend that you look into that, because as of now, it is not currently registered as a vacant property. That being said, Mr. Chairman, we wouldn't object to more time, providing a limited time to get permits pulled and to register, and a limited time to complete the vacant property registration. As such, the city will concede to close the rental registration violation notice. As this is a condemned property that does not allow occupancy anyhow. So the rental registration is not required.
At this point, right? So the time that we're looking for is to bring it out of, to get the permits. So we're looking at what, 30 days, June 20th, 2025 to obtain the permits required, and then some time to have it either re-inspected or whatever needs to be done to take it out of condemnation. Board members, you got any idea on what we're thinking about time-wise for that?
If we give 30 days to permits, does the code then take over for the normal sequence of progress and work?
It does.
Okay, that'll do it then.
Mr. Chairman, discussion?
Yes.
We would also ask for no more than 30 days to complete the vacant property registration.
Right, okay. So motion is in order to obtain the permits and complete the rental registration. That is to June 20th, 30 days, 2025 to accomplish that. Motion?
Mr. Chairman,
Yes.
clarification.
Yeah.
I believe it's the vacant building registry, not the rental registration.
Is that correct, Mr. Vanover?
That is correct, Mr. Chairman.
Okay.
Thank you, Mr.
All right.
Pettis.
So we'll add that to the motion. That is a vacant registration. Motion. I think we had Mr. Bradley.
Yes.
Okay, and second, Mr. Denk.
Mr. Bradley? Mr. Maskey?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you. I don't know. Okay, thanks.
Okay, next docket is housing docket A 245-24, 3271 East 116th Street.
Application and fees are in order. Notice of violation is exterior maintenance, issued on October 28th of 2024. Appeal was received December 17th of 2024, requesting until June of 2025 to complete abatement of the violations. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastoral, and Chief Billing Official Tom Vanover. Will the applicant or his or her attorney and/or representative please state your first and last name for the record as well as your relationship? Mr. Chairman, I do not see Barbara Ruffledge in the participants panel. Or is that person present in room 514 this morning?
Okay, Mr. Vanover, do you swear or affirm to tell the truth, the whole truth?
I do.
Mr. Jacobson?
Mr. Chairman, this is Dan Jacobson from the Law Department. Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, or anything physically delivered to you on behalf of this appellant and or docket?
Through the chair to Mr. Jacobson, no.
To the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with its hearing and ruling today. Thank you.
Okay, thank you. Mr. Vanover?
Mr. Chairman, this is an exterior maintenance notice that has been issued out of our Main Street inspection unit. And for, exterior, gutters and downspouts. Short of any testimony, we ask that you, to the contrary, we ask that you deny any more time and remand it back to the Department of Building and Housing.
Motion is in order to deny more time and remand the property division of Building and Housing for any further action. Motion?
Moved.
Moved by Mr. Bradley,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maschke,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes, notice will be sent out within 2 weeks. Housing docket A 246-24, 3356 East 142nd Street.
Application and fees are in order. Notice of violation is condemnation of the garage, issued on November 20th of 2024. Appeal was received December 16th of 2024, requesting for 60 days to complete abatement of the violation. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastoral. For the Department of Law, Chief Billing Official Tom Vanover. Will the applicant or his or her attorney and or representative please state your name for the record? Mr. Chairman, I do not see Mr. Abdul in the participants panel, or is that person present in room 514 this morning?
Okay, I see somebody had got up and left, but we don't have any name to him. So, Mr. Vanover, do you swear or affirm to tell the truth, the whole truth?
I do.
Okay, Mr. Jacobson?
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, or anything physically delivered to you on behalf of this appellant and or docket?
Through the chair to Mr. Jacobson, no.
To the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with its hearing and ruling today. Thank you.
Thank you. Mr. Vanover?
Mr. Chairman, it appears that there has been a certificate of disclosure submitted for this property indicating the attempt to, or an appetite to sell it. We would ask that you deny more time and remand it back to the Department of Building and Housing.
Motion is in order to deny more time, remand the property to the Division of Building and Housing for any further action.
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Maschke.
Mr. Bradley,
Yes.
Mr. Maschke,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Notice will be sent out within 2 weeks. Next docket, housing docket A 248-24, 3378 East 134th Street.
Application and fees are in order. Notice of violation is exterior maintenance, issued on the November 14th of 2024. Appeal was received on December 5th, 2024, requesting for more time to complete, requesting for 1 year to complete abatement of the violations. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastro for the Department of Law, Chief Billing Official Tom Vanover. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record?
Hi, this is Rory Brock, and I'm the owner of the property.
Okay, Ms. Brock, do you swear or affirm to tell the truth, the whole truth?
Yes.
Okay, go ahead and proceed.
So I had purchased this property through an auction, and I had started work once I received the deed at the beginning of 2024. I had pulled a permit and got a new roof, and the contractor I was working with ran off on me. Had another contractor start. He had pulled a permit as well, ran off on me. And I'm currently working with my current contractor, and we have just completed that top porch there. We fixed that. He's currently working on the bottom porch and the masonry around the house. We have fixed some of the siding. That should be complete in the next 2 weeks. And we are getting started on repairing and replacing the gutters. The frames and new windows have been put in areas that needed them. And yeah. I've been working with Inspector Malik Alam and Inspector Lang as well, making sure that we are getting everything complete and up to code.
How much more time do you think you need?
Honestly, I would like everything to be complete inside and outside by July. But exterior work, I'd say 30 days. It's hard to say, with contractors, they say one thing and then, the 3 weeks, 2 weeks kind of turns into that. But I'd say within the next 30 to 60 days, everything should be complete exterior wise.
So this is a 3-family residence, so you do not live here, do you?
No.
Okay,
No one lives
this
there.
is strictly a rental property, okay. Mr. Vanover?
Mr. Chairman, there are active permits and there's an active permit and there's also a permit pending as well that is pending issuance. So, Mr. Chairman, to the appellate, you have a permit that was finalized 5/12/25 that is waiting for you to pick that up. We don't object to August 21st, 2025 to abate the violations, Mr. Chairman.
Okay, so motion is in order for August 21st, 2025 to abate the violations. Motion
So moved.
moved by Mr. Dink,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you.
Okay, next docket is housing docket A 251-24, 6611 Ovington Avenue.
Application and fees are in order. Notice of violation is condemnation of the main structure in the garage. Issued on September 25th of 2024. Appeal was received December 19th of 2024, requesting for 12 months to complete abatement of the violations. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, and Melissa Pastoral for the Department of Law, Chief Building Official Tom Vanover. Will the applicant or his or her attorney and/or representative please state your name for the record?
My name is Marty Buford. I'm the owner of 10 Down LLC.
Okay, Ms. Buford, do you swear or affirm to tell the truth, the whole truth?
I do.
Okay, go ahead and proceed.
We submitted the application for a permit for 6611 Ovington Avenue to complete renovations back in January of this year. In March, we finally heard back from Rodney Wells, who is the person in charge of approving or denying the application. He requested that we submit professional architectural drawings. We paid for the architectural drawings and then submitted them in April. He responded last week stating that the roof plan needed more details. The architect is currently working on the drawings now. So although we are excited to start the work, the contractors cannot proceed until we actually have permits approved.
Okay. How much time do you think you'll need once they become approved?
Just because of the nature of the job, I would still need 1 year to complete the work. Just because it's nothing and we purchased it like that.
Okay. Mr. Vanover.
Mr. Chairman, we don't object to more time. Obviously, we won't. We do object to a year. There is, there's an expectation it was purchased this way. There's an expectation that there's enough resources to get it done quickly. That being said, we don't object to, 180 days to abate the violations, with the understanding that the permit process is ongoing. This is a house that's more than a typical condemnation. There is structural framing, there is structural, foundation work, and it's more than just replacing what is there. It's actually rebuilding what is there. That being said, as long as the work is progressing and the work is continuing, the permits will allow for extensions of time.
Okay. So motion is in order for November 20th, 180 days, 2025 to complete the abatement of the violations. And as the chief building inspector said, stay busy on it, stay working on it, and you'll eventually get it completed here. Motion.
So move.
Moved by Mr. Bradley.
Second.
Second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Notice will be sent out within 2 weeks. Thank you.
Thank you.
Housing docket A 252-24, 10400 Mount Auburn Avenue.
Application fees are in order. Notice of violation is interior and exterior maintenance. Issued on November 27th of 2024. Appeal was received December 23rd of 2024, requesting for 6 months to complete abatement of the violation. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastor for the Department of Law, and Chief Building Official Tom Vanover. Will the applicant or his or her attorney and/or representative please state your first and last name and your relationship to the property for the record?
I'm Kevin Matthews, owner of the property.
Okay, Mr. Matthews, do you swear or affirm to tell the truth, the whole truth?
Yes.
Okay, go ahead and proceed.
Oh, okay. So I had some violations. They really kind of minor, but the tenants, they're not paying their rent, so I can only do what I can. I did do the back porch upstairs and downstairs and the stairs. I just need a little bit more time to do the front porch ceiling, and because I had to replace one of the tenants' kitchen sink and all that stuff, so it kind of threw me back as far as the money go, because I'm not getting the rent like I'm supposed to. So I just need a little bit more time to do the ceiling on the front porch, and I was gonna try to paint the whole house too.
Okay.
And the driveway. Sorry about that. The driveway. That's gonna be like a difficult little thing. I'm gonna have to try to get somebody to fill those holes.
Okay. So how much more time do you think you need?
6 months at least, because I think I'm gonna have to change tenants. I hate to do that because I became homeless before, and that's the only reason why I haven't did anything as far as the tenants go. I'm trying to work with them. 6 months would be, I think it would be enough time for me to get it all together, because it's really not that much. But like I said, the money thing is what's holding me back a little bit.
Okay, Mr. Vanover.
Mr. Chairman, we object to 6 months. This is an investment property. It's a rental property. So there's an expectation that one has the resources. We don't object to 60 days to correct the violations, but we would object to anything longer than that.
Okay. We could give you the 60 days to make sure you keep yourself working on the project. That's the main thing. That'll keep you going in good stead with the inspector. So we're looking at July 20th, 60 days, 2025 to abate the violations. Motion?
So move.
Okay, moved by Mr. Bradley,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you.
Next docket is a lead housing docket A 247-24, 1012 Prospect Avenue.
Application and fees are in order. Notice of violation is a notice of deficient lead inspection findings for the property located at 1012 Prospect Avenue. Issued on October 8th of 2024. Appeal was received November 7th of 2024. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastor for the Department of Law, Chief Billing Official Tom Vanover. Will the applicant or his or her attorney and/or representative please state your name for the record?
Mr. Chairman, if I could interrupt, this is Chief Assistant Director of Law, David Roberts. We reached a settlement with the appellant and his attorney, and he signed it this morning. And so they're under the settlement. We're giving them the opportunity to correct the deficiencies in the report and have it be granted. And in return, they're withdrawing the appeal.
Okay, so if it's withdrawn, then that's what we'll put down. We'll have no action on it.
Yes, thank you, Mr. Chairman.
Okay, so that, go ahead.
Mr. Chairman?
Yes.
We didn't receive anything from the applicant. Should we consult with Vishnu about the withdrawal? They hadn't submitted anything to us as far as withdrawal.
Okay, all right, Mr. Ganglani, go ahead, comment.
Yeah, through the chair, the applicant is not here, and through the chair to Chief Roberts, do you have correspondence, or Melissa, would you have correspondence about the withdrawal?
I can hand you, I need this copy back, but I can hand this to you to
Sure,
review.
yes, and I can read it on the record too.
We can make a quick copy too.
Okay. Mr. Chairman, the city's just provided a settlement agreement which states in relevant part that appellant does agree to withdraw the pending appeal. So it would be reasonable to accept this as a statement of withdrawal.
Okay, thank you, Mr. Ganglani.
Thank you. And we'll make a copy and have that.
And I apologize. I will say as well, Mr. Burkons was here earlier. He signed that and stated, will withdraw, like that should take care of it. So.
Thank you. Thank you.
Mr. Chairman, give me a few minutes so I can make a copy. Okay, Mr. Chairman.
Okay, second, this is a second, lead housing docket A 112-25, 1969 West 44th Street.
Application fees are in order. Notice of violation. It's a notice of deficient lead inspection findings for the property located at 1969 West 44th Street, issued on April 1st of 2025. Appeal was received May 6th of 2025. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastro for the Department of Law, Tom Vanover, Chief Billing Official. Would the applicant or his or her attorney and/or representative please state your name for the record?
Yes, Art Lauer, owner, Rogue Song LLC. And I believe I have my witness with me, Mike Heller.
Okay, so both Mr. Lauer and Mr. Heller, do you swear or affirm to tell the truth, the whole truth?
Yes.
Okay,
Yes, I do.
okay.
Mike Heller here. Sorry.
Go ahead, you're up, go.
Hi, I'm here just for the record, I am an Ohio attorney. However, I am not here in that capacity. I was the lead clearance technician who did the clearance examination that we are appealing. So, but that is my role here today.
Okay, thank you. Do you have any further comments?
Are you addressing me?
Yes.
Go ahead,
well,
Mike.
Yeah, whoever wants to talk on
Okay.
this.
Gentlemen of the board, I'm a licensed, well, I was an Ohio licensed lead clearance technician. I'm now a risk assessor, but in any event, I had done, actually, there's two properties. Probably the next one coming is 1973 West 44th. And by way of note, the issues are going to be essentially identical. So I had done, and Mr. Lauer is, excuse me, the member owner of Rogue Song LLC, and as far as 1973, I believe it's AP Properties. I had done both of his properties excuse me, 2.5 years ago. I did the lead clearance examination. I passed. He was certified. And because it has to be redone in 2 years, he had contacted me last fall, August or September, I can't remember exactly, and said, "Hey, Mike, my 2 years are coming up soon. I'm not sure the exact date, but I'd like you to redo the inspection," which I said, of course. And but he said he had to go out of town and he would contact me when he returned, which he did. And push came to shove. It was, I believe it was early November when I came out to do the inspection, but in the interim period, the mayor had issued an executive order stating that they were switching to risk assessments rather than lead clearances. And frankly, I didn't have any advance warning of that, but we went ahead and did the lead clearance exams. The properties, they're very nice properties. They're in the Ohio City Historical District. They're very well kept, clean, nice, no deteriorating paint. And we passed the clearance examinations. I submitted the applications, and I'm actually kind of speaking on 1969 West 44th and 1973 West 44th, which again is apparently docketed separately, but the issues are the same. We submitted the applications to the city, and they were rejected because they said that because they.
One sec, Mr. Chairman,
Yes.
could you please ask the applicant for our court reporter to only stick with the current docket that we have in front of us, which will be property 1969 West 44th, and we would take testimony for 1973 West 44th when that docket is called. We do not want to confuse the record.
Okay, my apologies, that's fine. So, again, so we submitted the application, which I prepared as the lead clearance technician, to the city. The house, it's a 2-unit property, 1969. It passed. The lead levels were below the required, the maximum allowable. And then the building and housing apparently rejected the application on the premise that we initiated the testing on November 11th, whereas apparently the mayor's executive order stated that they were only going to accept risk assessments going forward. Now, I would point out, quite frankly, I believe, number one, the mayor's executive order was was on extremely short notice, number one, and number two, it was a little vague in terms of what would be accepted post October 18th, that there was language about performing the test after before October 18th, but I would argue that our initiating conversations and maybe Mr. Lauer remembers, it was September or August or September when we set it up, so to speak. So I would argue that we actually initiated the testing on that date. And I would say that, number one, I would argue that the test was timely in perspective of the mayor's executive order. And number two, I would argue that in view of the fact that Mr. Lauer has been a diligent, law-abiding homeowner with nice properties, and that he had taken steps to get it done, I believe that we should be permitted to go forward with that application. That application should be accepted and his property should be deemed lead safe certified. So that's basically my position on this matter. So if Mr. Lauer would like to comment, I will turn over the floor to him.
Yes, that's correct, Mike. Before I left in September, I said, well, it looks like it's, you know, coming up the time we have to get these tested, and sometimes it takes a while. So if you could take a look at, you know, at least the exterior and make sure that I'm in shape. And then when I get back in November, I can get you inside the property, which is exactly what we did. So we started out before the mayor issued this proclamation.
Okay, let's see what the city has to say. Mr. Vanover.
Mr. Chairman, I will defer to Chief Roberts as well, but in essence, the law changed, and laws change as they do, and the executive order was specific. Conversation about a future imaginary inspection does not constitute the inspection taking place. We would argue that the law is lawful, that the executive order is lawful. This is not the venue to dispute that anyway, and that by conducting the beginning and conducting the test after the executive order, it must follow the law as it was at that time, which required lead risk assessments and not lead clearances.
Okay.
I will
Mr.
defer
Roberts.
Yes, Mr. Chairman, Mr. Vanover stated it well. I would point out this, when you make a change, as Mr. Heller had indicated, you do want people to get notice of it, and then they can adapt their choices based on it. If they have already relied on what they thought was the law prior, we recognize that that should be accepted. So people who began to do lead clearance testing before the change, they relied on the prior law, and they should be allowed to finish using the prior law. But Mr. Lauer and Mr. Heller are clear. They talked about getting started, but they didn't get started until November. Well, in November, they should have been fully aware that the new law required an assessment, not a clearance. So they're not qualified for any kind of grandfathering, and you should deny the appeal. Thank you.
Okay, thank you. So any further from the appellants, any further comments?
Yes, sir, I would like to just respond to those last couple of rebuttals. Number one, I would argue, or I have argued, I believe the executive order, first of all, I didn't have notice of it until practically the day before it was issued, before October 18th. So when I spoke to Mr. Lauer initially, again, that was in, I guess, September, that didn't exist, or at least I didn't know about it. But number two, you know, the first gentleman had stated that that was an imaginary or, you know, future inspection. I'm going to disagree. I think that those were affirmative initial steps towards performing the inspection. I would also argue that the mayor's executive order was vague. It was not entirely clear when it said, you know, the inspections that are being performed. And I would argue that that's sufficiently vague, that our conversations and having set it up and having a history of having done a prior inspection 2 years ago is sufficient to comply with the mayor's executive order of having initiated the process prior to October 18th. I mean, I frankly think there's additional legal issues and possibly even constitutional issues regarding the mayor's executive order, but I don't think I'll get into that here. But nevertheless, I think that Mr. Lauer, again, a very diligent, long-time, law-abiding property owner with some beautiful properties in the Ohio City Historical District, should be granted the certification. I probably should have pointed out, we have Mr. Lauer did submit copies of the applications as evidence. I didn't point to that, and it wasn't referenced in this proceeding, but I believe the board has received copies of the application for lead safe certification that we submitted, which has all the pictures, all the lab results, and the whole 9 yards. So I thank you for the opportunity to speak, and again, I disagree with the city on their position. Thank you very much.
Okay, thank you, Mr. Heller. Well, I think Mr. Roberts' assessment of the law is clear that it was not something that was being done but performed after the date. So I believe that it would be our job that we will have to deny that, and he will have to do a risk assessment. So your motion is denied unless other board members have a different opinion. Motion to deny your request.
So moved.
Motion.
So moved.
Okay.
Second.
All right, moved by Mr. Dank, second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks.
Discussion,
Question?
Mr. Chairman.
Oh, yes, go ahead, Mr. Vanover.
We would ask that the motion include the statement that the notice of deficiency was properly issued.
We will include that in the motion, that the notice of deficiency was properly issued.
I'm going to respectfully object to that because I don't believe it was properly issued. I found out about it from
Mr. Chairman, to the appellant, the witness, Mike Heller, is a witness in this proceeding. I'm not sure of his authority to object. Thank you.
Okay. All right. We'll uphold that.
Okay, well,
we can redo the motion to include that in it, that it was properly issued. Motion.
That motion is acceptable.
Okay.
Seconded.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks.
and just FYI, I respectfully disagree with the last comment, but I think I made myself clear on that. Thank you very much.
Okay, next docket is lead housing docket A 113-25, 1973 West 44th Street.
To correct the slide that we presently see, this property is actually owned by AP Properties LLC. Application and fees. Application and fees are notice of violation. Is notice of deficient lead inspection findings for the property located at 1973 West 44th Street. Issued on April 1st of 2025. Appeal was received May 6th of 2025. Present for today's hearing, Dan Jacobson, Chief Dave Roberts, Melissa Pastor for the Department of Law, Chief Building Official Tom Vanover. Will the applicant or his or her attorney and or representative please state your first and last name and your relationship to the property for the record?
This is Art Lauer. I'm the owner of AP Properties LLC. And my witness, Mike Heller, is with me too.
Good morning, Mike Heller. I am just for the record, I am an Ohio attorney, but I am not appearing in that capacity. I was the lead clearance technician who conducted the lead clearance examination that this appeal addresses.
Okay, we're gonna swear yours in now. Do you swear or affirm to tell the truth, the whole truth?
Yes, I do.
Okay, go, whoever's gonna be making the comments, go ahead and proceed.
Okay, thank you. I'll begin, Mike Heller. Again, I know this is a separate record. First of all, just as a matter of technical correction, the lead housing docket reads Rogue Song LLC, but I believe this property is owned by AP Properties LLC. Am I correct, Art?
Yeah, that's correct.
So yeah,
I believe that was corrected by the executive secretary.
okay, because that's on the screen. So, okay, one more time, and at the risk of being redundant, but I know we have to have an independent record for a separate case. So, Mr. Lauer, who's the member manager of AP Properties LLC, the owner of the property at 1973 West 44th, which is a 3-unit property. There's a 2-family house with a 1-family house in the rear. I had done his lead clearance examination in 2022. Which passed, and the house was it's a beautiful, clean, nice, well-kept house in the Ohio City Historical District. And then in September of 24, Mr. Lauer had contacted me and said, "Hey, Mike, my 2 years are coming up. Can you do the re-inspection again for me, please?" Which I said, sure. And he stated he was going out of town. And when he came back, he'd call me and we'd go do the inspection, which we did. Now, in the interim, in the intervening time, of course, the mayor issued his executive order that effective October 18th, they would be requiring risk assessments rather than clearance examinations. But, any examinations that were being performed would be still accepted after that date. And I argued, number one, there was not sufficient notice because I didn't even get that notice in any form as a clearance technician. I got it from a third party, a different client of mine who told me about it and sent me a copy like on 1 or 2 days before the 18th. And number two, the language in the executive order to the effect that properties where the inspections were being performed would still be accepted. And I'm arguing that's vague. That's, how do you define that? We started performing it when he contacted me and said, "Hey, Mike, go do it." I had gotten I had supplies prepared and so forth and so on, and I was ready to do it. I had a staff member who comes out to assist me with some of the paperwork. It was all lined up. So we actually did the actual inspection, if I'm not mistaken. I can't remember the date when we first inspected it, but it was after October 18th. And again, Mr. Lauer submitted a copy of the application that I submitted to the city. I believe it was submitted in February, but the board should have a copy of that application for lead safe certification. It has pictures, it has the application forms, descriptions, it has the lab results. So the house passed the lead clearance examination. It's a beautiful house. There's no deteriorating paint whatsoever. It's very clean, well-maintained, beautiful house. And the city rejected the application on the premise that we supposedly began the test in November, whereas it was past the October 18th date that the mayor stated in his executive order. So just in summation, my arguments are that number one, we began the process in September, which was before October 18th. The mayor's executive order was vague because it didn't really clearly define what the parameters were, and there was not sufficient notice because I didn't even know about it till the day before. So I believe that the application should be accepted and lead safe certification be issued for this property. Okay, thank you. I'll yield to Art Lauer at this time.
What Mike said is correct. And again, we started it in September, well before this proclamation came down. I have a feeling I know what the outcome is going to be. Now, we're going to be against time constraints now if we have to go do a lead assessment, and as well as getting my rental certificate. There's a way to extend that time for us.
I'm going to go over to Mr. Vanover. So there'll be a question for him. Mr. Vanover.
So, Mr. Chairman, in two parts, I will again defer to Chief Roberts regarding the facts and the timelines. However, the application for the rental registration can still be made and still be applied for while the lead risk assessment is being undertaken.
Okay.
And then it's just awaiting the approval of that.
Okay. All right. So there's your answer, Mr. Lauer. Mr. Roberts.
All right.
Thank you, Mr. Chairman. The city's argument is the same. The grandfathering idea that you could finish a lead clearance after the executive order was based on the idea that you had started that work. And Mr. Lauer and Mr. Heller concede that they started the work after the executive order was granted. And so they don't qualify for the grandfather. Thank you.
Okay. So the motion is in order that the notice was properly issued and that that we are going to deny your request.
May I
Okay.
rebut that comment, please?
Well, go ahead.
Okay, number one, I disagree with the characterization that we started the work in November. Again, I've argued that the executive order was vague in the sense that it didn't really define what the beginning of the process was. And I argue we began the process when Mr. Lauer contacted me. So I believe that we did in fact begin the process after that October 18th date. And I respectfully disagree that I conceded that we started work in November. My argument is we started work in September. So and I also respectfully have argued that I don't believe the notice was sufficient, accurate, adequate, or timely, or properly served. So thank you very much.
Okay. So we have a motion that the notice was properly issued. We're denying their request for the acceptance of that, their request to accept the lead assessment that they did. Motion?
So moved.
Okay, moved by Mr. Maskey,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out in 2 weeks. Thank you.
Okay, thank you.
Thank you.
Okay, I believe we can log off.
Yes, you can.
All
Thank
right,
you.
Art, I'll give you a shout later on today. Okay? All right, thank you.
Okay, Mike.
All right.
Okay, the next docket is adjudication order, docket A 106-25, 2043 Random Road, apartment 202.
Application and fees are in order. This is an adjudication order to a B permit B 250-05396. The applicant is asking for a waiver of item number 3, provide additional structural graphic text information as listed below per RCO 106.1.3, section 10. This adjudication order was issued on April 30th of 2025. We received the appeal request on May 2nd of 2025. Present for today's hearing, Dan Jacobson, Law, Tom Vanover, Chief Building Official. Will the applicant or his or her attorney and/or representative please state your name and your relationship to the property for the record?
My name is Alan Lee. I am one of the owner occupants of the unit.
Hello, my name is Amy Van. I am the other owner and occupant of the building. We are also joined by someone from Payne & Tompkins, which is the company that we hired for this project. Matt.
Hello, I'm Matt Orris, representative from Payne & Tompkins.
Okay, so I'm going to swear all three of yous in. Do you swear or affirm to tell the truth, the whole truth?
I do.
Yes.
Okay.
Yes, I do.
Okay, very good. So whoever's going to be speaking, go ahead and proceed.
All right, thank you all for your time. So our property is an 850 square foot condo. It's in the historical building in the Murray Hill High School in Little Italy. Our unit is very small, but we truly love it. One of the unique features of it is it has a loft, a storage loft above the kitchen in the image that you can see right here. And our project with Payne and Tompkins is to improve the safety of our loft. Even though it is just, it's not part of any living space, it's still very important to us. It is our primary storage. And again, in our 850 square foot unit, it's very important to us. So we use it several times a week, very regularly. We use it as most folks would probably use a garage or a basement or a storage shed in the backyard. So our project with Payne and Tompkins has two primary goals. One is to enclose the loft so it's not just an open ledge, and the second is to upgrade the existing ladder. We also would defer to Matt for any technical details.
Yes, thank you, Amy. You spoke very accurately about that. We wanted to make this kind of a perceived closing off the space, but not make it so that you couldn't see through it. That's why we're closing it off with the glass wall. And then also to the ladder system that they have to access it now is it's on rollers and it slides back and forth. So it feels a little unsafe to them. So our objective was to construct a permanently attached welded steel ladder, something similar to, it's actually kind of exactly, that's not the fabricator that's going to custom make the ladder. That's another one that fabricator has made in the past. So the one that we propose to use on this project is very similar.
Okay, so any further comments?
I'd just like to get your guys' take on what we can do to basically get this ladder to meet code and to hopefully get a permit and be able to move forward with this project.
Okay, Mr. Vanover.
Thank you, Mr. Chairman. So begin to speak, there's the adjudication order is clear on how to get it to meet code. The code requires egress components. If a ladder or this type of stairs to be used, it has to be a ship's ladder. This is a situation where this space does not require an egress, a means of egress, because it's not living space, it's not habitable space, and it is just a storage shelf. However, once an egress component is introduced, it must meet the requirements of the code, as a ship's ladder would. I will tell you from personal experience that the original approval of this space did not include a ladder at all. So there is an existing rolling library style ladder that was most definitely added after the fact. And it's just a matter, Mr. Chairman, the code doesn't allow it. If there's going to be an egress component, it has to meet the requirements of the code. And this is a situation where having no ladder complies with the code, where having adding a ladder that's less than fully compliant does not meet the code. So there is no, other than providing a permanently affixed ship's ladder per the building code, there is no way to make this code compliant. So therefore, they're asking for a variance.
Okay. So I'm going to need.
I'm sorry, Mr. Chairman, go ahead.
Ask the board members to comment if they've seen something like this. So any comments from the board members?
Through the chair to the appellant, I have a question. If the requirement for a ship's ladder is differs from your intentions significantly.
I'm sorry, could you clarify that? I'm sorry, I don't quite understand the question.
I'm having trouble understanding the difference between the requirement for a ship's ladder and the plans that you have for a ladder of some sort that does not comply. I don't know that I'm appreciating the difference.
The difference in what our ladder system doesn't meet in terms of the code.
The difference between the ship's ladder and your ladder.
Yes. So in reading the code, and it seems like some of the requirements are that the treads are not less than 5 inches. We were proposing 6 to 8 on our ladder. That the riser height is no more than 9.5 inches. I think ours was drawn at approximately 10, which we can certainly modify to meet code. We didn't know exactly how big because this particular ladder system was going to be custom fabricated to fit the space once it's ready. So, we know about how big the treads or how big the risers are going to be, but that will be field fit, once we get to that point in the project. And then in terms of having a railing, we thought by using 2 steel tubes welded to run up and down that the treads are attached to, that does provide a handrail. So, maintain 3 points of contact as you climb the ladder system. And then in terms of, weight rating, the manufacturer is telling us that this is easily 400 plus pounds weight rating.
Mr. Chairman, to the appellant.
Go ahead, Mr. Maskey. I think he can hear you.
Typically, a ship's ladder has the railings are it's almost like a chute on either side, so you're contained, so you will not fall side to side if you slip. Are you opposed to doing that with your ladder?
If we could attach some kind of railing to the sides of it that would contain, I believe in the code it says the handrail shall form not less than 30 inches and not more than 34 inches. So correct me if I'm wrong, but that would mean that the railing would have to extend out from the ladder 30 to 34 inches.
I don't believe a ship. I have included ship's ladders in some of my work, primarily exterior sides of buildings, not in the interior. And I do not believe they're that deep. And I know that you can either have them custom made locally, because I've done this, or there are product that you can purchase. I would go back to your architect or your contractor and see if they could satisfy that, because I think that's an easy solution.
And Mr. Chairman, to Ms. Davis, if it's possible to pull up the adjudication order, because the adjudication order does define those other items. The term ship's ladder, I apologize, it is a colloquial term. It's really, the requirement is an alternating tread device, and alternating tread stair. So there is more to it than just the railing. It's also the fact that it needs to be permanently affixed, which I believe the expectation for this ladder is to be able to pull it out when it's being traversed and then pull it up and place it tight to the wall when it's not.
That's correct. It was designed in that manner that it wouldn't move back and forth, right? But that at the base of it, it would have locking wheels, so that way it could pull away from the wall and then obviously tuck back in tight, just because this is a small space, trying to utilize as much of that as we possibly can. If I could revisit one of the earlier questions, we would love to move forward with this project for Amy and Alan. If we, it would be great if we can come up with a ladder solution that does meet code. If we weren't able to do that, would it be possible to proceed basically the rest of the project and have no ladder, and they could just use a folding A-frame ladder that they currently have to access the space?
Mr. Chairman.
Through the chair, to the appellants and to the board, to the other board members, it appears that this is turning into a discussion on how to go about the design. I'm wondering if the board wants to, and I would defer to the board on this, but whether the board wants to give the appellants some more time to figure out what they want to do and hone in on the exact request based on the last testimony that was given by Mr. Matt. Thank you.
Okay, we can certainly look at the rest of that order. I think Mr. Vanover asked Ms. Davis to read that off. Is that correct?
Yes, if we could display the adjudication order.
Mr. Chairman, to Mr. Vanover, the adjudication order letter itself is not in the presentation.
Okay.
Okay, so Mr. Chairman, I would agree with the board's counsel that any changes or alterations to this design, I would ask to be submitted as such and reviewed with and if either re-adjudicated for the board to discuss. I will point out the fact again that this space under the code does not require a ladder. So if the appellate's desire is to remove the ladder from their design, then and resubmit separately for the installation of the ladder, I believe that's a path to approving all other portions of the design.
Okay, very good.
But we would ask that you uphold the adjudication orders properly issued. And you can either, with this information, determine to grant a variance or to deny the variance. Either of those actions does not prohibit the appellant from altering their design to submit for the ladder separately.
Okay. Well, obviously, it's not acceptable the way it is, so I don't think that we can approve. Well, I don't know. I guess it's up to the board members, but I don't think we can approve this design.
I think that Mr. Chairman, I made the decision, and just again to speak from the the appellant's testimony, to consider whether this ladder or an A-frame ladder, which an A-frame ladder is not regulated by the building code where this one is.
Okay,
The
gotcha.
board does have the authority and the ability to make determinations of ultimate, use and safety and things of that nature.
Well,
Okay.
and Mr. Chairman, only speaking for myself, because of the small size of the unit and the appellant's desire to maybe incorporate a ladder and the limited access that they will have to this loft area, I don't know that I'm personally opposed to granting a variance of some sort if they do desire to incorporate a ladder that isn't fully, depending on the details, fully compliant.
Okay.
Just
So
speaking for myself.
Not this one though, right, Mr. Denk?
I don't know that we know enough about this one to grant
Okay.
that variance at this time. Correct.
Okay. Then what about the rest of the adjudication order then?
It being properly issued, I agree with that.
Okay.
And Mr. Chairman, to the appellate, this is the only item on the adjudication that you're appealing, correct?
Correct.
Okay, so the motion or the notice was properly issued, and we are going to deny, I guess, having any variance to this at this time. So that's something you'll have to do, rework that out, I guess. So the motion is to that the notice was properly issued and that we are denying any variance to this order?
So moved.
Moved by Mr. Dank,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Maskey,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank
Can
you.
I ask a clarifying question, please?
Okay, who is, is Miss Lee?
Amy Van, one of the owners.
Sorry, Miss Van. Go ahead.
My question was just that I want to make sure I understand correctly. I understand that this motion was denied, but that the rest of the design, not the ladder, would be approved. Is that correct if we resubmit that permit?
I don't know what's in the rest of it. I'm assuming that everything is good. If you're not appealing anything to that, you're not asking for any variances for the rest of the order, just for the ladder. So I'm assuming everything would be okay, but I don't know that for a fact. Is that correct, Mr. Vanover?
Mr. Chairman, I'm looking for the adjudication order. I apologize. But I would, our position would be that with, as a response to the adjudication order, assuming all of the other items, any other items are addressed by the designer, the design professional, and then as a response, the removal of the ladder, then yes, it would be approved.
That's your answer.
Without seeing the balance of the items, I can't affirmatively speak to that, but yes, that is the.
Okay, thank you very much.
Yeah, appreciate the feedback. Just so if I can ask also a clarifying question, just moving forward, so hopefully we could help Amy and Alan out with this. Is there anybody that at my firm, is there anybody within the building department that we should be able to contact in the next, just so we can keep this ball rolling and maybe get the right stuff removed from the permit application?
Yes, you can send an email to me.
Mr. Vanover?
Yeah, it's tvanover@clevelandohio.gov.
I'm sorry, was it E or D?
Excuse me? T.
I'm sorry, could you
Vanover.
say the email address one more time?
Oh, clevelandohio.gov.
Okay.
So it is T as in Tom in the beginning.
Yes.
Thank you, sir.
Okay, so notice will be sent out within 2 weeks. I believe you got everything you need at this point. All right, that wraps it up. Any other questions? We're good?
Nope, thank you.
Okay, all righty, thank you. Appreciate it. All right, next order of business is approval of resolutions. First, let's see, resolution A 222-24, A 231-24 through A 239-24, and A 241-24. Motion?
Move.
Motion by Mr. Bradley,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Approval of minutes for May 7th, 2025. Are there any additions or corrections?
No.
No. Motion?
So move.
Moved by Mr. Bradley.
Second.
Second.
Okay, second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Is there anything else to come before us?
No.
All right, then we're adjourned. Okay.
Have a
Thanks. Have a
meeting.
good holiday.
Thank you.
Thank you.
All right.